Good afternoon. I want to thank everybody for logging in and calling in today for our seminar on the Checkbook IRA, how it works and what you need to know. This is a subject that we get asked quite a bit here at Advanza about individuals looking to obtain greater control over their self-directed IRA. With the self-directed IRA, you're already gathering and gaining a lot of control simply by self-directing it. But using a checkbook control type structure really adds an extra layer to that particular transaction. So just wanted to kind of give you some slides and let people know a little bit more about the checkbook IRA itself. My name is Scott Maurer. I'm the Director of Business Development for Advanza IRA. I'm a licensed attorney. I don't do any legal work on behalf of Advanza clients, but I've been with the company now for over 10 years, working primarily initially with people looking to set up an account, and start a self-directed IRA account and walking them through that process of not only getting the account set up, but then also getting their investments made as well. I spend more of my time now basically educating people about the possibilities that exist with self-directed IRAs and walking them through what that looks like and answering a lot of questions day to day from people who are interested in self-directing. One disclaimer I'd like to point out, things that we don't do at Advanced IRA that's I think very important to understand, is that in Advanced IRA, although I'm an attorney, I don't provide any legal advice. We don't provide any tax or investment advice either with a self-directed IRA account. We exist to hold the alternative investments within your retirement plan and administer them according to your direction. When it comes to making decisions regarding your account from a tax, from a legal perspective, it is up to you as the client to reach out to a CPA or an attorney to help you get that type of information. We can always refer you to individuals who will help you make those decisions and who are familiar with self-directed IRA accounts. This is especially true of the topic we're talking about today when we talk about checkbook control and using an LLC, using a private trust possibly, to really get good upfront counsel either from a CPA, from an attorney, to let you know what the process is going to be and give you proper advice on how to manage and operate that particular entity. Now, before we get into talking about specifically the checkbook control, I want to kind of cover a couple key points I think that everybody should take away or look to take away from today's seminar. Certainly, what accounts you can self-direct. Whether you're using a checkbook or not, it's important to understand kind of what accounts, what monies can you actually use to self-direct should you choose to go down that route. Also, kind of the key point of what we'll talk about today, to spend a bulk of the presentation on, is what does it look like if you're looking at investing in, say, real estate using your IRA account? What does it look like to have the IRA administrator take control and actually handle all the books and handle all the records versus using the checkbook IRA or using an LLC or a trust, and what the different roles, responsibilities are if you're using either kind of they call the custodial model or using the administrator to do it versus taking direct control yourself in the form of a checkbook control IRA. Lastly, I think the biggest part to take away towards the end of the seminar, as well at least to consider as you move forward, are what are the advantages and what are the disadvantages of checkbook control. This seminar today is not meant to provide you with the blueprint for this is what you exactly how you should do it. It's mainly going to provide a couple of different options and allow you to make that decision, again, maybe talking with your own attorney, your own CPA to help you get that particular answer when it comes to using checkbook control. Now, in general, why haven't people heard of self-directed IRAs? I think the biggest reason why people are unfamiliar with self-directed IRAs, and I'm not sure how many people on this call would consider yourself at least a novice with a self-directed IRA, but I'm sure there are a few. Most people are not familiar with or not comfortable with, I guess, considering and thinking about self-directed IRAs because they're conditioned to think that most of their IRA funds need to be with a bank or a brokerage firm, and these are the places that most people associate with retirement accounts. Your local Bank of America branch, you have a CD there, maybe you have a trading account at E-Trade or a mutual fund account at Vanguard. Those are more familiar to people. And again, most people haven't heard of self-directed IRAs because those institutions, while they're great at what they particularly do, they don't offer you the ability to invest your IRA into a lot of different types of assets, like real estate, like private notes, the checkbook control structure we'll talk about today, the precious metals. So you have your retirement account, you have it with that firm, you're going to be limited to what they offer. The IRS, though, allows for a much broader range of investment. The IRS will allow you to do a lot of different things, again, real estate, mutual funds, stocks, bonds, etc. But each custodian, whether that be Advanta holding a self-directed account or Vanguard holding a mutual fund, each custodian can decide what it is that they are willing to hold. And so again, the banks and brokerage firms simply made the decision not to hold things that they don't sell. And in Advanta, we don't sell anything at all. We simply allow for individuals to invest in what they choose, what they find is an investment, as long as it falls underneath the guidelines we'll talk about in some of the rules. It's up to you to decide with a self-directed IRA to control your own investment. The only exclusions, again, the IRS says the only things you can't do, you can't buy life insurance and you can't buy collectibles. Those are the only two prohibited in investment. Now, we'll talk about some other potential problem areas with disqualified persons in a minute. But again, the IRS allows for a very broad range of investment. It's up to each individual custodian to decide what they're willing to hold. Now, the benefits of self-direction, having been in this business for over 10 years and talking with clients repeatedly over the years, and new clients as well, a lot of the same themes come out for why people choose to self-direct. One can be very simply looking to get more diversity within your retirement account. You have an account with stocks, you have an account with mutual funds, just looking to put some other type of asset to really give you more diversity within a retirement account is a big reason that people will choose to self-direct. Also, being able to choose the investment that you understand. The stock market, the mutual fund market makes sense to some, doesn't make sense to others, or perhaps investing in real estate or investing in mortgage loans makes much more sense to you than does investing in the stock market. A lot of people at this point in their life might not be comfortable with the stock market, may want to get away from the stock market, be able to sleep at night. Being able to choose something else that they understand, have at least a better understanding of, again, is attractive of why people choose to self-direct. And when you're investing in self-directed IRAs, a lot of times you're investing in tangible assets. In today's presentation, we'll talk a lot about buying real estate, either, again, using a checkbook control method or not. The real estate that's at the core of the investment within the IRA account is something that's tangible, something you can look at, something you can see, something you can touch, and know that you feel much safer that that is your particular investment asset. That's where your retirement funds are currently held, not in a stock account, not in a mutual fund account, where the value could fluctuate quite a bit, and you're not really quite sure what exactly it is that you're holding. Now, we'll not spend too much time on some of the kind of finer points of the types of accounts that can be self-directed, but mainly just to make you aware, if you're listening to the presentation today and thinking about, okay, what money do I have, where is it located, what could be used to do what Scott's talking about during this webinar. Any type of IRA, you have a traditional individual account, or a Roth individual account, or you have a SEP or a simple IRA because you own your own business or you work for a small business, any type of IRA can be self-directed. It's a matter of simply transferring it from your current custodian over into a self-directed account. We also offer at Advanta an individual 401k plan. This is what they consider a qualified plan, or the IRS at least considers a qualified plan. If you own your own business without employees, you have the ability to set up a single member, a solo 401k plan itself to be able to make that investment. We also offer any former employer's plan. I wouldn't say that we offer a former employer's plan, but any former employer's plan can be used to self-direct. So if you have an old 401k, you have a 403b plan, you have an old 457 plan, those accounts can be rolled over into a traditional IRA and then in turn self-directed from there. So if you're looking again at your money, you say, I don't have an IRA, but I have one of these old employer plans, those accounts could possibly be used as well. And we do offer education, health savings accounts if those particular accounts make sense for you as well. One of the questions we would get, though, from an individual looking to self-direct is they have money in an IRA, they have money in an old 401k. How do I get that money from where it's at into a mechanism that I can in turn self-direct? And it's just different terminology. I think it's important for people to understand and realize the tax implications of those particular investments as well. If you're moving money from one IRA to another, it's considered a transfer. Okay, it's a non-reportable, non-taxable event to move money from one trustee to the other without the money ever touching your hand. So again, because it's going directly from one custodian to the other, the non-taxable, non-reportable event, this is how we typically move most of the funds, at least, within the particular IRAs that we hold. If you do have money in an old employer-sponsored plan, like a 401k or 403b, Typically, you move the funds to an IRA or a self-directed IRA by doing what's called a direct rollover. Again, taking that money, having the custodian of your 401k or your 403b send a check directly to Advanta or into your IRA. Again, the money doesn't touch your hands. That's also a non-taxable event. The last way people move money, we strongly discourage. It is possible for you to take a distribution from your IRA account. If you take it personally, you have the right to roll that money back in within 60 days to another qualified account to avoid any tax implications. This can only be done once per 12 months, and if you do try to do a second rollover during that time, you can certainly subject yourself or would subject yourself to taxes and or penalties for doing so. So that's the reason why we discourage the indirect rollover. Important thing to remember, if you have money in another IRA or you have money in an old employer's plan, you can take the money from that plan, move it into a self-directed account, and not have any tax implications for doing so. And you can do it an unlimited amount of times by a transfer or direct rollover. And also important thing to remember is any earnings within your IRA are also unlimited as well. So when you're looking at how much money your IRA can earn in a given year through rental income, through interest income, that is unlimited also. I kind of want to go over and talking about checkbook control specifically. It's important to understand the entities that can be used, or at least entities we've seen clients use to establish and obtain checkbook control over their accounts. One of the most common way we find people getting checkbook control is through using an LLC, or also known as a limited liability company. So when you're thinking about an LLC, and again, I'm not sure how many of the familiarity of individuals on the call with LLCs. A lot of people, especially investors, have some familiarity with an LLC. I just want to kind of lay out some of the terms that we use when we talk about a limited liability company to make sure everybody's on the same page. Within an LLC, a member is typically someone who is a shareholder, somebody who has an equity stake, who has contributed capital, who has contributed assets in exchange for membership within the LLC. So a member is the equivalent to a shareholder in a corporation. Just again, different terms are used depending on the different type of structure. So a lot of people, again, are familiar with being a shareholder in IBM or a shareholder in Coca-Cola by buying stock in that particular corporation. When you are investing into an LLC, you are buying a membership interest, and your IRA becomes a member within that particular LLC. So again, a member is someone who has equity, who is a shareholder of that particular LLC, and whoever is in charge of the LLC, the decision makers, are referred to as managers, or if there's only one, maybe just a manager of an LLC. So a manager is someone who acts as the officer or president of that particular LLC. Again, the person who's going to be able to sign checks, sign documents on behalf of the particular LLC. The other important document that's especially crucial to understanding what it is, because it's a document that we require at Advanta to see that your IRA is indeed investing in LLC, is an operating agreement. Now again, within a corporation, again, people have heard the term corporate bylaws, and a lot of people have that understanding that a corporation's bylaws sets out how that corporation is going to be run, who the owners are, how stock is issued, how officers are appointed, etc. Within an LLC, that similar document to corporate bylaws is an operating agreement. So within an operating agreement, typically the members are listed, again, so who list out who the owners are, their ownership percentage, and would also list perhaps who the managers and who the officers are within that particular LLC as well. Now, operating agreements, like bylaws, can range anywhere from just being a few pages long to 30 to 40 pages long, just depending on who drafted them, who's involved, and of course as well the different provisions that you want to add into that particular LLC. When we get into talking about IRAs and using your self-directed IRA to invest through an LLC, it's important to note that an IRA cannot be a manager or a managing member of a particular LLC. An IRA is an inanimate object, or an inanimate entity, I should say, and doesn't have signatory authority. So your IRA would never be listed as a manager or a managing member of an LLC. The IRA would need to be listed in the operating agreement as a member of that particular entity. Now, if the IRA owner personally is a manager, they cannot receive compensation or commingle any personal funds. Again, that's another thing just to remember when you're setting up your IRA. If you decide to act as manager, you cannot receive any compensation or commingle any of your personal funds into that particular LLC account. Now, I just had a question pop up, and I would encourage anyone who's listening today, I forgot to mention this at the beginning, if you have questions as we go through the presentation, please type those into the chat box on your screen. I'll be more than happy to address those as they come up and get those questions answered. Now, we had one pop up that said, why is there a differentiation made between a rollover and a transfer? Since the funds are coming from one custodian to another and the IRA holder is not touching the funds, why have a rollover and a transfer? I'm not exactly sure on the answer to that question. Only I can tell you that with a transfer and a rollover, they're usually initiated in different ways. So they might be the same in the sense that they're non-taxable events. They're non-taxable events. It doesn't matter. You're doing a rollover transfer. It really depends on the accounts that are being used. But the other difference is a transfer. If you are moving money, say, to Advanta, then Advanta needs to send a transfer form to initiate that process to your other custodian. If you are rolling money over from a 401k or 403b type plan, you as the IRA owner have to personally initiate that particular rollover. So you actually start the process yourself to do the rollover. And there is a little bit different reporting that's done with the rollover as opposed to a transfer. One question just popped up again. Another one, again, keep asking and keep them coming. Are the checkbook IRAs a target or a red flag for the IRS? That question is definitely left more for attorneys to address. We actually will be having a webinar coming up in just a few days from now as well with an attorney. I would advise you to sign up for that one and ask him that question. It'll be a webinar with attorney John Heyer, who will be able to address some of that. Certainly, I think the checkbook IRAs, when we get towards the end of the presentation today, talking about advantages and disadvantages, I think the checkbook IRA gives the IRS maybe more to go after, more things to look for, and it gives you possibly areas that you could make other mistakes, and that's kind of really the disadvantage. One of the disadvantages, I think they might be a little bit higher target than just a regular custodial IRA account. Now, some of the issues involved might be similar, but due to the fact that you're getting more control, could possibly get you in more trouble than just a custodial account. But that's something we'll talk about more at the end. Or again, join us for our webinar coming up in a few days. You'll get the invite for it to ask that question as well directly of the attorney we're going to have that comes on. Another question, I think, again, left for the attorney, and it just popped up, not for me, it'd be for your attorney. But if the IRA owner is not the manager, so a situation where you have set up an LLC, you've put your IRA in there, you have somebody else acting as manager, is it a good idea to compensate the non-owner manager? In the context where we're talking about checkbook IRAs today, where it's simply usually your IRA buying its own piece of property, that's a good question to ask your attorney and get their opinion on whether or not compensation is encouraged or should happen. If it's a situation where your IRA was investing into an LLC with multiple members, maybe you're investing into a hedge fund or a private placement, the question then, if that situation, I think oftentimes the managers are particularly able to do so. The attorney actually who will be joining us on the webinar today will be on the other. He said he would comp the manager, that he would pay them. So again, there's some guidance right there. He'll address the why though on the webinar that's coming up next Tuesday at noon. So make sure you sign up for that, check in for that. Kind of keep moving through the webinar again. Using the LLC again, we went over the terminology of the LLC. Again, a lot of the checkbook control industry started with the case of Swanson v. Commissioner. I'm sure John will cover that more so on Tuesday when we talk to him. But the cases at which the checkbook control is largely based on some of the two main cases that have come out over the years, the Swanson v. Commissioner case in 1996 that kind of paved the way for some of that activity, as well as the tax court memo on the Ellis case that came out a few years ago that addressed an individual trying to compensate themselves. So in that case, an IRA owner acting as manager and receiving compensation. That tax court memo addressed some of that and also addressed the validity of the checkbook control as well. So check out those court cases, and I'm sure, again, we'll have more for that to come in a webinar in a few days. But just some other notes on the checkbook control. There are other custodians out there that offer a one-stop shop where they charge you a couple $1,000s to get an IRA set up, get the LLC form, get the checkbook started. You can attain the same type of structure by using your own local attorney, using our services, and paying far less. So we don't really approve or disapprove of any investment structure. So there's some custodians out there that will not allow you to do the checkbook control. Again, our job is not, in our opinion, not to provide that legal advice and legal counsel. So we will allow that structure with a disclaimer. It's up to you to decide, again, ultimately whether that's for you or not. And again, talking with attorneys or CPAs who can either assist you with getting it actually set up or giving you advice. So we can certainly give you names of attorneys and CPAs as well who can help that out as well. The other main way we've seen people obtain checkbook control is instead of using an LLC, is using a private trust. So having a trust agreement as opposed to an LLC. Now, a lot of people are familiar with trusts. We see them in different areas of life, whether it's a revocable trust as an estate planning device, whether it is a special needs trust to care for a child or another disabled individual. You might see life insurance trusts that help fund payment of expenses upon death, whether that's estate taxes or otherwise. Now, the parties to all trusts have similar, they might have similar, or say dissimilar, I should say, functions, whether it's estate planning or special needs, but they have the same parties involved. The parties in a trust, usually there's three main parties that you would see. You'd have a grantor, someone who contributes assets to the trust, puts cash or puts assets into the trust, to then be managed by the trustee, who acts in a fiduciary role to oversee the assets, make investments on behalf of the trust, and act in the best interest of the trust. And then ultimately you have the beneficiary. The beneficiary be the party or the entity or the person who is ultimately receiving the assets in the trust. So if we look at a revocable trust, you might have a parent or a grandparent as a grantor set up in the trust and contribute assets into the trust. They might name a corporate fiduciary or a bank, someone to actually manage the assets in the trust, and ultimately their children or grandchildren are the beneficiaries that will receive the assets in the particular trust. When we talk about IRAs and having an IRA invested into a trust, the IRA is generally the grantor and the beneficiary of the trust. Your IRA survives your death, so your IRA will contribute the assets into the trust. You will choose a trustee, someone other than yourself or a disqualified person needs to act as trustee because of that fiduciary role. But then ultimately when the trust terminates, the IRA will still receive all of the assets. So your IRA both puts the money in and gets the money out as the grantor and beneficiary of that particular trust. The two main types of trusts we see with the IRAs, self-directed, either is a land trust that's holding simply real estate. Now, as we go through some case studies in a minute to illustrate the differences in these different structures, the land trust, Advanza will administer that like a real estate asset. We will pay the bills, receive the income. The land trust is used mainly just for titling. It's a little more similar to the custodial method of administering the self-directed IRA. Versus a personal property trust. We've seen individuals, it's very similar to a checkbook control LLC. They set up a personal property trust to hold notes, mortgages, other assets. They name a trustee, someone other than themselves, who gets a bank account open and who holds all the different assets in and out of that personal property trust. So we'll go through a couple case studies to illustrate some of the differences then between the LLC, the trust, and again the custodial method for holding real estate and getting checkbook control. Now again, I mentioned there's two investments the IRS actually prohibits within an IRA. That is either life insurance or collectibles, and your collectibles include your antiques, alcohol, artwork, etc. And there's also a number of disqualified persons that the IRS considers, or people that the IRS considers disqualified from dealing with your IRA account. The disqualified persons list, sometimes it seems like there's a lot of people because it's a lot of your close family members, maybe people that you trust and would like to do business with. But in actuality, it's a small number of people the IRS says your IRA cannot transact with. So for your particular IRA, the disqualified persons include yourself as the IRA owner, your spouse, your parents and grandparents, your children and grandchildren, and any spouses of those lineal descendants. And they also then include any business or entity that is owned or controlled by one of the above. So again, these are the people the IRS considers to be disqualified and prohibited from transacting with your IRA. Now, the area that comes, the question that comes up a lot with the checkbook control is when you look at a business or entity that is being controlled by you personally, so you are managing that particular LLC, but your IRA is investing into it, why isn't that prohibited? And that's really kind of what the IRS has addressed in the Swanson, actually I didn't say the IRS, the tax court has addressed in the case of Swanson and Ellis and some other decisions of maybe having a little bit of an exception there, that when you're setting up a brand new LLC that is not owned by anybody else and your IRA is investing into that and buying kind of the initial shares, that would not then be prohibited because that entity is not yet really in being and not really functioning and not yet prohibited. So it's kind of an exception, and I think John will probably talk a lot more about that on the webinar on Tuesday. Again, try to check it out to get the more of the legal background for that as well. But if you had an existing LLC, so you owned a piece of property personally through an LLC that you already owned, your IRA cannot do business with that entity because it is already in existence and it is being under controlled by somebody who's disqualified. So some just quick examples of things that are prohibited between an IRA and a disqualified person. Selling, exchanging, or leasing property. So you can't buy anything you already personally own or anything you already own through your own LLC cannot be sold or leased to your IRA, or your IRA cannot buy property with the intent on leasing it to somebody who's disqualified. Your IRA cannot lend money to a disqualified person, or a disqualified person cannot lend money to your IRA. And lastly, you cannot furnish any goods, services, or facilities. So if your IRA is purchasing real estate, and that particular real estate property needs some rehab work, needs a little bit of work, you or any disqualified person is prohibited from doing the work, whether you're paid or not, and certainly, again, any disqualified person or entity is prohibited also. So the key thing to remember with your IRA account when you're talking about disqualified persons, there's no self-dealing allowed, no dealings between your IRA and yourself or disqualified persons. And you can't get any personal use. The IRS also prohibits you or any disqualified person from getting any current benefit from your IRA account. So if you buy a piece of real estate and you look to go live in the property or stay in there even for a weekend, you now are personally benefiting, and disqualified persons are prohibited from getting any kind of current benefit as well. So if you have more questions kind of on this, I really invite you to call us. Again, sometimes the rules seem onerous, seems like there's a lot involved there. But with many of our clients who are out there investing, you're buying properties, you're making loans out of your account, these rules a lot of times will not come up and will not impact what you're looking at doing. So things to just avoid within the LLC or trust, and kind of the impetus of this slide, your IRA cannot, again, buy collectibles or life insurance. Okay? Your IRA, if you instructed Advantage to go purchase a collectible, go purchase a life insurance policy, we can't do it because it's simply prohibited directly under the IRS rules. If you were to instead put your IRA into an LLC or trust and get checkbook control that allows you to buy those types of assets more easily, it still is going to be prohibited. The mere fact of setting up the LLC or trust does not shield you from the rules we were just talking about. So likewise, as you can't buy collectibles and life insurance, you cannot deal with anybody who's disqualified. So again, setting up an LLC or trust does not enable you to then lend money to your son or your daughter or to your parents. And then you still cannot get a current benefit from any assets held within the entity as well. So again, if your IRA owns property through an LLC, checkbook control in your account, you cannot live in the property, vacation, etc. Still going to be prohibited. We touched on this earlier. You cannot pay any compensation from your LLC or trust to anybody who's disqualified. That was what was directly addressed in that tax court memo back in 2013. And if you were ever looking at borrowing funds, and this is kind of a subject, maybe a different subject for a different webinar, if your IRA was ever looks to borrow money, it has to be on a non-recourse basis. If you're using an LLC or trust, the financing still should be a non-recourse financing to your LLC or to your particular trust. I'd encourage you to attend one of our seminars that we talk about non-recourse financing and lending within an IRA to get a little bit more information on that. I want to spend the last half of the seminar, or last portion of the seminar at least now, going through a case study and kind of lay out some facts for an individual who has money in an IRA account looking to purchase real estate, and kind of go through the different ways that he could buy the property, whether using just the IRA itself, whether using an LLC or using a trust, kind of go over what the process looks like for each of those, and then go over kind of the advantages and disadvantages if he decides, deciding on which way Joe, in this particular instance, chooses to go. So we'll start off. Again, the real estate deal is very simple. Joe wants to buy a single-family home. He's got about $150,000 in his IRA. Wants to buy he's got his house, his eyes set on a particular property that he needs about $100,000 to purchase, another $20,000 to get it ready to rent. He anticipates buying this property, holding it for a long-term basis, and just continuing to get some net cash flow back into his IRA each month. So how can Joe buy this property? So again, he's got the money in his IRA, he's got cash, there's no financing involved, be a very straightforward deal. What are the different ways he can use his IRA to actually buy this property? Now let's go, first case study we're going to go through is Joe using his IRA administrator to actually buy the property. So he's going to use our services at Advanta to simply take title to the property and then administer the property in the name of his IRA account. So his first steps: 1, getting his account open and funded, completing the paperwork to open up the self-directed IRA, doing a transfer or perhaps a rollover, depending on where his funds are currently at, from his other custodian, get the account open, get the money moved over. We'll have an account number then issued for him in less than 24 hours, so he can then begin working on making an offer and working towards the purchase of this particular property. The next step for Joe: to identify the actual property. And sometimes the client comes to us, they've already identified the property in advance. They're coming kind of in a little bit backwards process to get the account open and get the property purchased. But in this case, when he identifies a property for purchase, so he's got his IRA open in advance, he identified the property, the contract should be written in the name of his IRA account. And this is, again, where our services as an administrator are letting him know, you're writing a contract, the buyer's name should read Advanta IRA for benefit of Joe Smith's IRA and his account number. Ultimately, Joe is going to approve the contract, send it to Advanta. He's going to initial off on each page that he has read and accepts the contract, sends it to us. We will actually then sign the contract and issue an escrow deposit directly from the IRA account. So he's rolled over the funds to us. We can then issue that escrow or earnest money deposit directly to a title company attorney to start the closing process. Once the contract's been signed and the earnest money has been issued, we will then work with the title agent or the attorney who's handling the actual closing. It's very important that all of the closing documents, the HUD statement, the settlement statement, the deed, the title policy, any other documents associated with the closing, show Joe's IRA account as the buyer. So that same wording that's in the screen on red, the Advanta IRA for benefit of Joe Smith, the IRA, his account number must show up on all of those documents. And Joe will need to review and approve those as well. So Joe will look over the deed, look over the settlement statement, make sure he approves of all the terms and conditions set forth. Joe will then send us his approval. And once we have Joe's approval, the next step is that we complete the closing on behalf of his IRA. So a representative from Advanta will sign the documents, sign the HUD statement, sign anything else as the buyer of that contract, and we also will then wire the funds out of his IRA for the purchase. After the closing, so the property has been purchased now, it's been closed, the IRA is now in his account. In this particular example, we sent $100,000 out of the IRA to the closing agent, so Joe now has $50,000 of cash and $100,000 property in his IRA going forward. So after closing, Joe would secure his tenant. He works on getting a tenant arranged, have his tenants send their rents directly to Advanta. They can simply make their check out to his IRA, mail it to our office. We will deposit it into his account. Any expense that comes up, the taxes, the maintenance, insurance, in this case he's doing some rehab up front, would be paid from paid by Advanta from the cash held in Joe's IRA. So he can simply fax us or email us that bill. We will then get a check cut out of the cash that's held in his account to pay those bills. Joe will then track the activity online and through email, so email notifications. He can go on any time to see his account online with us, see what's been paid, see the income coming in, and also our system will automatically email him of any activity, any changes to the cash held in his account. So he'll be able to track those that way as well. So we are acting then, Advanta is acting as the record keeper and the administrator of the account. We are holding the uninvested cash, dispersing it at Joe's direction to pay those expenses, and we are receiving the income and depositing directly into the IRA. So there's no checkbook control for Joe in this scenario. He's bought the property in the IRA, is now having us do all of the direction from there. So he can just simply hold this property indefinitely. The rents will continue to accrue to the IRA. If he sells the property at a later date, any profits on that deal will come back into the IRA as well. So now let's take a side step here. We've got the same scenario. Joe with $150,000 looking to buy a single family home as a rental property. In this case, though, he's looking at getting checkbook control. So what would this look like if Joe decides I want to use checkbook control? How will I do this with the LLC? What does the process look like for the same kind of example, just with this different wrinkle? I did have a question come up I just want to address quickly. Someone said, I bought some raw land. Should future tax obligations be paid out of the IRA, or should they be paid personally? Just going back to that last example, any expense related to that property, taxes, insurance, maintenance, etc., must be paid out of the IRA account. You cannot pay those personally. So, getting back to Joe. Joe has decided, first example, he's thought about, now he decides, well, I think I'd rather use an LLC and rather get checkbook control. What is that going to look like? Well, step one for Joe is the same as it was if he was using the custodial method. Open up an account by completing our application, rolling or transferring over funds, getting an account number issued. So again, the same process up front, getting started, is to get the account open and get money moving to get transferred over. For the next steps here, when you're deciding to use an LLC and get checkbook control through an LLC to buy property, the next steps are going to be quite different than what they were for buying simply a piece of property in the name of the IRA. If Joe has decided to use a checkbook LLC, his next step after opening the account with Advanta is to get an LLC formed in a particular state. He's going to choose what state he wants to set up the LLC and choosing a name for the LLC. But that is the next step, is to establish and get this entity going. Now again, we encourage individuals to use an attorney, CPA, maybe some other legal service to file the articles. Now the articles are what kind of, when you set up an LLC or corporation, and some of you on the call may have done this already, but when you establish an LLC, the state where you're setting up this LLC requires you to file articles of organization. Now these articles of organization will typically lay out the name of the LLC, the address, and who the manager is. So when drafting the articles, whether Joe's doing it himself or using an attorney or CPA, the articles will name him as manager to get true checkbook control. But the articles should not mention the IRA at all. When you are forming an LLC with any state, you do not have to list who the members are of the LLC. Now again, the member is the shareholder. In this case, the IRA is the shareholder. The IRA should not be listed anywhere on their particular articles that are filed with the state. Just the manager, the name of the LLC, and the address associated with it. A question just popped up. Does the LLC state of formation have to be the state the real estate is located in, or the state of the custodian? The answer to that is, I believe, no. Again, that's another good question for an attorney. But in most states allow foreign LLCs to purchase real estate there. You want to check, though, with each state that you're dealing with to make sure that's the case. But many people elect to set up LLCs. Some of them, I think, practically you set up the LLC in the state where the property is located. It just seems that that's how it happens. For the most part, if I live in Florida and I buy rental property in Florida, I'm probably going to set my LLC up in Florida. But there's other reasons why you may not choose to do that, and I don't think there's any rules that prohibit you from doing that. So again, there's another comment coming in. Usually the best states for property is that there's other states you can choose from. That's more of an attorney question to answer that particular, what state's best to form. But when you set up, again, the first step, setting up the Advanta account, getting money moved. The second step, getting the LLC started in the state that you decide to set up the LLC. And then the next step from there is drafting the operating agreement. Okay, now the operating agreement, again, is the document that's going to show the IRA, in this case, as the 100% owner of the LLC. The IRA is going to be the sole member. The operating agreement is the one document that we need to see at Advanta, because when our job at Advanta, when we're buying an asset, whether it's a piece of property, whether it's an LLC interest, whether it's a private mortgage note, we need to see the IRA reflected on those ownership documents. And since in an LLC, the operating agreement will designate who those particular owners are. The operating agreement will show the IRA as a member. In that same listing we saw in the last example, Advanta IRA for benefit of Joe Smith's IRA and his account number should be reflected in the operating agreement as the member of that LLC. And again, this is where an attorney or CPA can help you out quite a bit who maybe are more familiar with operating agreements if you're looking at getting one of these started. Now, our job at Advanta will be to review the operating agreement, make sure that the IRA is listed as the member, make sure Joe, as the account holder, has approved it, and then ultimately we will sign the operating agreement on behalf of the IRA, and we will issue a check from the IRA to fund the LLC. So instead of sending money directly to a title company, Advanta can issue a check for the full $150,000 that Joe has in his IRA, make it payable to his LLC, and then Joe can go open up a bank account, kind of the next step. Goes and opens up a bank account in the name of the LLC, uses the check from the IRA to fund that entity. Now his LLC has been established, his LLC has been funded, and from Advanta's perspective, we are, in a sense, somewhat done then with this transaction for Joe. The IRA has made an investment into buying all the shares in the membership of this LLC. The LLC now has cash. When Joe goes to buy the single-family home that needs the work, he will enter into a contract to buy that property in the name of the LLC that he's established. He will sign all the closing documents on behalf of the LLC in his position as manager. So he will sign the purchase contract on behalf of the LLC. He will sign the settlement statement on behalf of the LLC in his position as manager. Once the property has been closed in the name of the LLC going forward, Joe will have an LLC that owns a piece of property and has a bank account with $50,000 in it for him to use to pay any expenses. So the taxes, the maintenance, the insurance, the rehab work, any expense associated with that property, Joe will pay that expense as the manager out of the cash that's being held in the LLC bank account. Once the property gets rented, any tenants that are making their rent checks out, they will simply make those payable to the LLC and deposit those into the LLC's bank account. So in a sense, Advanta, we've purchased the LLC on behalf of his IRA, but all of the record keeping, receiving rents, paying bills, keeping track of all that, is now up to Joe as the manager of the LLC. So Joe now has an enormous responsibility to make sure that he's following the right rules and he's keeping good records of that particular LLC. If he has extra cash in the LLC, he could always reinvest that into other assets. He could open up a brokerage account in the name of the LLC. He could open up a CD in the name of the LLC and hold different assets all under that same umbrella. Now, the last of purchase of assets using a trust. Again, the same process for regardless of how you choose to do it is opening up and funding the account, completing the application, transferring money in. But then instead of, in the last example, using an operating agreement if you're using an LLC, if you decide to use a trust to get checkbook control, you would have to have a private trust agreement drafted. So again, whether you get that from an attorney or somewhere else, the trust document must show the IRA as the grantor and as the beneficiary of that trust. So again, we would be looking at Advanta not at any real estate contract or other documents. We would be looking at the specific trust agreement that shows the grantor and beneficiary listed as Advanta IRA for benefit of Joe Smith's IRA and his account number. Now, when we do trust, the way we read the rules, again, there's some case law that suggests, you being the manager of the LLC, at least that one singular aspect of it is allowable. There is no similar case study for trust, so we require, at least Advanta's requirement, that if Joe uses a trust, he's going to have to name somebody who's not disqualified to act as his trustee. Whether that's a brother, sister, friend, someone else who's not disqualified, that's up to Joe, but we will not permit Joe to act as his own trustee or any disqualified person to act as trustee. Now, the trust is not public record, so again, contrary to an LLC where you would file articles online with the state, the trust is a private document. We would ultimately sign the trust on behalf of the IRA. Once again, Joe has approved the trust itself. So he would again give us the trust document showing the IRA as the grantor beneficiary, mark it as approved, have his trustee sign it, get his non-disqualified third party as trustee. Then ultimately we sign the trust agreement on behalf of the IRA and can then send a check payable to the trust for Joe's trustee to go open a bank account. Now, it's important, again, with an LLC or a trust that you get a separate tax ID number either for the LLC or the trust to open up the bank account. You do not want to tie, if you're establishing a checkbook structure with your local bank, please make sure that they use the tax ID number for your LLC or for your separate trust. You do not want to tie that bank account number to your own social. So in this case, Joe's trustee gets the tax ID number for that trust, opens up a bank account. Joe's trustee can now take the check that's from the IRA that's made payable to the trust to deposit in the bank account and go forward kind of in, again, a similar capacity with the LLC, just using a trust instead to get checkbook control. Now, how does a trust operate? Again, because Joe can't be the trustee, he needs to instruct his trustee what assets to purchase. The trustee will ultimately sign the documents, enter into contracts, etc., and then the trustee will be responsible for depositing income into the trust and paying any bills. So it's just a trust. You can obtain kind of checkbook control with it. You just have to have a third party acting as your trustee. It's just in a little bit different process. There are advantages and disadvantages to using trust versus an LLC. That, again, is a question you would talk to your attorney about, talk with other investors about to figure out, would you rather have an LLC? Would you rather have a trust? What are you looking to do? That's not something that we get involved with at Advanta. We just say, you make that decision of which way to go. We will let you know what documents we need in order to process that investment. Now, again, the two main types of trusts that we see with an IRA are either land trust or personal property trust. Now, if you were simply looking for anonymity on your purchase, so you don't want to have Advanta's name on there, you don't want to have your personal name on there, you don't want to have people know that the property is held in an IRA, you could set up a land trust to simply hold title to the real estate. If you do that, we will still act as the record keeper for the account. It's just when you enter into the contract, the name of the buyer is in the land trust. The land trust agreement would show your IRA as the beneficiary. You as the account holder, in this case Joe, would still approve all the closing documents. His trustee would sign the closing documents, but if you're using a land trust, you can still have the rents and expenses flow in and out of the IRA itself. So we at Advanta can still take in the rents, still pay the bills if you're using a land trust specifically. If you elect to use the personal property trust route, that is more in line with the last two examples of the checkbook control, where Joe's trustee will open up a bank account, purchase the assets through that particular account, and maintaining all the records of income and expenses as well. So what about partnering with the IRA using an LLC? The kind of another thing individuals bring up from time to time. A lot of times when you're putting a deal together, it may not simply be your IRA account. You may be looking for other people to come and be involved in the property. Maybe in Joe's example, he needs more cash. He needs more capital. He wants to buy a bigger property. So he might use multiple parties, including maybe other people's IRAs, to buy that particular asset. And a lot of times when individuals are looking at partnering on a particular deal, they may choose to set that up in the structure of an LLC. So instead of the last examples we were talking about where it was just Joe's IRA, this case you might have multiple people. You can still use an LLC structure. It's just in that case, when the IRA is partnering on this investment, the IRA must receive its share of income and expenses. So if you're using an LLC, if your IRA is putting in 25% of the overall capital to the LLC, your IRA must receive ultimately 25% of the income and pay 25% of expenses. So an LLC can make it less cumbersome. If you are doing multiple parties, the LLC can allow you to kind of consolidate all your funds into one particular entity and then nominate a manager to actually hold all of the funds and make the investments there as well. And kind of go through a very quick case study of how that process can work using three different brothers all having money within their IRAs and looking to partner on a particular deal. You have Sonny, Michael, and Fredo all looking to buy property using their IRAs. Or actually, I'd say Sonny has a Roth, Michael has a traditional, Fredo has some personal funds. Figuring it easier to, instead of having multiple moving parts, let's just form one LLC, put our money into that bucket, have one of us act as a manager, and we can then buy and sell the assets in and out of that particular LLC. So in this case, when they form an LLC, the Corleone brothers are going to list in their operating agreement the three members of that particular LLC. The three members would be Advanta for benefit of Sonny's Roth, Advanta for benefit of Michael's traditional, and then Fredo personally would be listed as the three members. Again, our job at Advanta would be to make sure that the two IRAs are properly listed in that particular operating agreement, make sure Sonny and Michael have reviewed and approved the document, and ultimately we will sign the operating agreement on behalf of the two IRAs and send funds from Sonny and Michael's IRA into the particular LLC. Michael, as the manager of the LLC, he will open up the checking account, sign as manager on any document, and again, the operating agreement must show that each of those particular parties, the two IRAs and Fredo personally, are a one-third owner in that particular LLC. Just a reminder, again, if we are buying, in this particular instance, Sonny, Michael, and Fredo are looking at buying a piece of rental property or buying a rehab project within this, using these different funds, we will want to see the LLC operating agreement, not the actual real estate closing documents. That will be up for Michael to sign and for Michael to review as the manager of that LLC. And just some things to remember, if in this situation we had three different individuals partnering up on a deal, if there was ever a capital call for the LLC, and you can talk to an attorney about whether or not you should ever make a capital call, but in the event you ever decided to make a capital call, each party in this instance would need to put up their corresponding percentage of that capital call to maintain the one-third ratio of ownership. Okay, so if they needed $15,000 additional cash, $5,000 would need to come from the Roth, $5,000 from the traditional, and $5,000 from Fredo personally to get into that particular LLC. You need to maintain those same percentages. If Sonny or Michael decided to put that money up personally and have it not come from the IRA, that would be a prohibited transaction, okay, because they personally are now contributing personal money in when it's their IRA that is the actual member. If they also wanted to add a fourth member to the LLC, they need to be careful again about who they are adding. So let's say that they have the three of them are in the LLC, they want to involve a fourth person. Again, it's important that the new member should be somebody who is not disqualified, or else it could result in an indirect prohibited transaction. A question just came up, is this the arrangement permissible for spouses to partner in an LLC to purchase real estate? This is when we've seen people, say spouses buying property together with their IRAs, we have seen them use the custodial method where you have just two IRAs both listed on title and both listed on the contract. That is fine to do. And we've seen other people use LLCs as well. When you partner two IRA accounts or an IRA and some personal funds, the key thing is that the ownership should show that each IRA owns a specific percentage based on what it contributes to the deal. So it is possible to partner, but you want to be very clear that the percentages of ownership are based on what each party contributes to the deal. So you can use an LLC or not if you're looking to partner with spouses. Going forward, just another question we get kind of coming up from time to time, how do I get the money out? Okay, so in Joe's example, he put $150,000 into an LLC. He's buying and selling real estate and out of that LLC, but now he wants to take a distribution. He wants to have money to go on a vacation, on a cruise, use to go buy a new car. How does that money actually get out? If you are using the checkbook method and you have that control in an LLC or trust bank account, it's imperative for you to send that money first back to the IRA as either dividend or income from the LLC or trust back into the IRA account. We will deposit the cash into your IRA at Advanta, and then you send us a distribution form requesting us to send that cash back to you personally as a distribution from your IRA. We will then send you the funds and also issue the 1099 that keeps the IRS happy. A lot of people look at this and say, you know what, why can't I just cut you out as the middleman at Advanta and just take the money out personally? Well, that the IRS could definitely look at if you did that and say that's prohibited. You took money from your IRA personally, just paid yourself without going through the proper channels. For peace of mind and to sleep at night, send the money back to Advanta first. We will turn around and send the money back to you and do the proper reporting with the IRS. So again, that's kind of very key to using this type of structure. We'll kind of wrap up the webinar here, and I'll be happy to take some more questions as we go through, but kind of the pros and cons to the different structures we talk about. Now, using the IRA as administrator to purchase the property. So the very first example we talked about where Advanta will hold title, we will receive income, we will pay bills. The pros: keeping an arm's length from your IRA funds. Okay, you're not in direct control of those funds. You're directing all the activity. That's certainly an advantage to having us do that, and keeping yourself away from the transaction makes it, number one, less likely that you will engage in a prohibited transaction. If you're having to request Advanta to buy an asset or make a purchase, if we see something that's clearly prohibited, we will let you know, and not only let you know that it's prohibited, tell you we won't do it. So we've had people and clients in the past get in trouble with the IRS because they engaged in something prohibited without really realizing they were doing so because they had checkbook authority. But if we're handling the cash, you have to pass those transactions through us, and also by having us receive the rent, pay the bills, we have a very clear record of all the activity held within the IRA. We can run a statement of your account in a matter of moments that shows all your income in, all the expenses out. The IRS ever to audit you or to look into the account, we have a very clear record of that activity. The cons to using us as the administrator: if you are looking at buying multiple assets, you're doing a lot of different deals, you're purchasing many different deals, there would be some more administrative fees involved in having us hold those assets. Now, that could be a con, simply you're paying more fees. Certainly, though, other people have said it's much better to go ahead and just pay more in fees and not have to worry about your checkbook control, not worrying about things that could be an issue later on. Another con, depending on if you're buying properties at auctions where you bid at 10 o'clock and you have to pay by 10:30, that's difficult for Advanta to work in that short a window. Using a checkbook control structure allows you at least to write the check for those immediate purchases. So the con to using us is sometimes it can be difficult for us in those situations, although there are some workarounds. The checkbook control a lot of times can make that process a little bit easier. So the pros and cons to using a checkbook control, some of them a little bit flip of what we were just talking about. Again, if you're buying property at auctions, you have quick access to it. Checkbook control, if you're the manager or your friend's the trustee, you can write that check right then and there on the spot, make that purchase. You can hold more assets in your account. We charge an administrative fee, just a flat fee for your LLC, regardless of how many different assets your LLC holds. Since we're not involved in administering those assets, your fees would be lower if you're using checkbook control to hold all those different assets. Another pro is getting asset protection or anonymity from that particular structure. Now, then again, this is a question to ask an attorney about and find out which structure gives you the best asset protection, keeps you the most anonymous if those are your concerns. Again, when we title real estate in the IRA, it's Advanta IRA for benefit of your name and your account number. If anonymity is your only concern, we can leave off your name and just simply title it as Advanta IRA for benefit of account number such and such. That being said, some people don't even want to let people know that this is an IRA-owned property, so a checkbook control structure would give you more anonymity and, again, some possible asset protection there as well. But again, the downside, with a checkbook control structure, whether it's an LLC or trust, you are now going to be tasked with keeping accurate records and making sure you don't engage in anything that's prohibited. So if the IRS were to audit your IRA involved in a checkbook structure, they're going to want to see your checkbook IRA bank account, and you should be able to document all of the money coming in, all of the money going out of that particular entity. You have your account with Advanta, and Advanta is acting as the administrator and is acting as in the custodial method of buying real estate. We would have those records readily available and all of the scans of checks and bills that we've paid over the years. And again, using this structure, there's a lack of oversight by the administrator. There's things kind of something might be a clearly prohibited transaction that we would be able to help stop and then help you prevent you from doing. When you have the checkbook control, you can simply make the investment and write the check right then and there. So we have another question come up, and we'll address that now, and then we'll get into kind of wrap up the webinar. In the past, I've borrowed against my Roth using a non-recourse loan. How would this work with an LLC? Very simply, I think if you were going to borrow money within your LLC that you've set up with your Roth, you just want to make sure that when the LLC borrows funds, that the lender include language that this is a non-recourse loan. And you'll also then want to ensure that when you are signing any documents, any loan documents, that you are signing solely in your capacity as the manager for the LLC. If they're asking you to sign personally, or sign as a guarantor, that would then be prohibited and not be a non-recourse loan. So that's the key thing. And again, that's even though we don't have to be involved with an LLC, if you're going through that strategy and you're looking to borrow, give us a call. Send us a copy of the loan documents. Maybe we can look over it very quickly and alert you to any potential problems that we see. Another question, what are the average fees for handling the property if we're handling it? We charge a flat $295 a year to administer the account. That includes us, I should say $295 a year for each asset. So for one particular property for $295 a year, we will receive the rents, pay the bills at your direction, do any reporting to the IRS, etc. Where the LLC benefits you from a fee perspective is if you were buying several different properties, instead of paying $295 for each one, the checkbook control, we would charge you simply one $295 a year fee for that one LLC. But if you're looking at just buying one rental property, the LLC versus buying using the custodial method is going to be the same from a fee perspective. Another question, can I set up my self-directed IRA with Advanta administering the transactions and then later add checkbook control? Yes, you certainly can. You can go either way. We've had people set up an account with us, had us administer it for a period of time, get comfortable with how the IRA works, and then decide later to move all their assets, move their cash into an LLC structure, and get checkbook control at a later date. Similarly, we've had people who've started with checkbook control and bought assets through that entity and decided after a while they just didn't want to be involved with that structure anymore, and it was easier to simply move everything back into the IRA and have us administer it from there. So you certainly can go back and forth between those. So there might be some additional documents that have to be drafted, like a deed or assignments, etc., but it can certainly be done. So again, the 3 key points is to wrap up the takeaway from the seminar. Hope we got it today. If not, I encourage you to call me afterwards with other questions. We talked about what accounts you can self-direct, whether you're doing checkbook control or not. We went over the different ways that you can buy real estate and buy assets, whether you're having us do it as the administrator or whether you're using a checkbook control structure, whether it's a trust or an LLC. And then a few minutes ago, we touched on the advantages and disadvantages of using checkbook control. There's certainly other pros and cons to doing that, and you're certainly more than welcome to call us with those as well. Another question just popped up. Is there any responsibilities for recording of assets held in an LLC and their values to Advanta? Any annual auditing processes as well? On an annual basis, we do require all of our clients to update us as to the value of the assets held in the account. So if you were buying property in and out of an LLC, the responsibility for you is to make sure those assets are getting properly titled, whether it's real estate or otherwise, that the LLC is the actual owner, and you would have to report to us an annual valuation of all of the assets held in the LLC. We do not need to see all the documentation, all of the purchase documents, etc. We just need to see at the end of the year an annual auditing letting us know what the value is of your particular LLC and the assets held. We do not need to see a ledger of all of your buys, sales, expenses, rents, etc. We just need an annual valuation at the end of the year. However, you should be keeping a ledger, so if the IRS would ever look into the account, you can show them all of your income and expenses in that particular LLC account. So there's no annual auditing from us looking at the day-to-day activities. We just need an updated value on an annual basis. Next question, is there any added liability protection using an IRA-owned LLC? Again, that's a question for an attorney to answer. It's going to vary largely on what state you might be using. Different states have different levels of protection for LLCs in general. Some states, if you have a single member LLC, for instance, it's just your own IRA, you may have very limited liability protection. Other states, you might have much greater protection. So again, that's a question more for an attorney to answer and get an opinion there. If you're having multiple parties in an LLC, a lot of states do have added liability protection from that standpoint. But again, another question to talk to your attorney. So which option is best for you? Ultimately, consult with your attorney, CPA, others. You work with other investors from time to time or know others. Which way would work best for you? I mean, we can certainly provide references to attorneys, to CPAs, to help you make that particular decision. There's a lot of factors to each one. It's certainly not a catch-all. of saying if you're doing this, then you should do, if you're doing A, then you should do B. Each individual has their own circumstances they're dealing with. So talk with us. We can refer you out to other sources as needed. A lot of clients do simply allow for us to hold the assets and do the record keeping. So although checkbook control is talked about a lot and can be a popular way for some people to do it, most of our clients simply buy the assets in the IRA and allow us to do the record keeping. As the question came up earlier, you can switch strategies later. Okay, this might be deeds and assignments that are required. But we really will not provide counsel or advice on which way you should pursue. Now, we can certainly go over, as we have done today, pros, cons, advantages, disadvantages, but it's ultimately up to you to make that decision. Getting started is easy. I'd encourage you to contact us, get the process going with getting an account open, getting the account funded, and then ultimately finding the investment. It is a better strategy, a far better strategy to have your account opened at least, even if it's only partially funded, in order before you go out and start looking for your investments. You want to be able to get contracts written in the name of your IRA or in the name of your IRA LLC right off the bat, and have that going and not kind of working backwards. So contact us today to how to get started. You can certainly contact me. Here's my email and my phone number. Anytime, I'm always available to answer questions from people who, whether you're a client or not, or whether even if you're a client or with another firm, one of our competitors, I'm more than happy to answer some questions for you, tell you a little bit more about Advanta and why choosing us or why working with us is a good idea and what we offer from that standpoint. Also, visit our website. Other upcoming events, seminars, webinars are always on our website. It's a wealth of information. As I mentioned, we're having another webinar coming up this coming Tuesday with the attorney John Heyer. If you're listening to a recording version of my seminar today and it's already past next Tuesday, we'll be recording the seminar as well with John as well. We can always play that back for you also. So please attend our events. They're always free. They're always just educational. Sign up whenever you'd like. At this time, I know we've run over by a few minutes. We'll thank everybody for their time today and listening and logging onto the webinar, and we look forward to hearing from you.